Welcome to Conversations with My Real Friends. I'm Jennifer. I'm here with my friend Bob Triplett. Bob owns Family Security Law Group, and today we're going to talk about a challenging topic, which is cognitive decline. So my grandmother had Alzheimer's, and I watched her decline, and it was horrible. She had an estate plan, so we had a mechanism to deal with it. So let's talk about what happens when someone is not able to make decisions for themselves, if they have one and if they don't.
So if they do not have one, which is the majority of people out there, and one being a durable power of attorney, both for finances and for health care.
Correct.
Then they have nothing.
Right.
So we're off to court on a conservatorship. And a conservatorship, if you're not aware of what they are, it's a court proceeding where the court is being asked to appoint someone to oversee a person who's infirmed.
Right.
It's the last thing the court wants to do. They don't want you to clog their court calendars anymore either. They just don't want to do it, but they have to.
Yeah.
The person who's appointed then becomes the conservator, the fiduciary, who has to oversee everything. Financially, then they have to keep records of everything that's going on. They're going to have to account to the court every 2 years of what went on during the prior 2 years in a format that the court dictates and has to approve. And if it's not in the proper format, the judge just says, we're going to continue this, and we're going to continue this, and continue until you get it right. And then we will honor that particular account, let's say. And that happens every 2 years until the conservatorship ends, which could be at the death of the person. So this is an ongoing probate. People have heard of probate. Well, a death probate's bad enough, but this can go on for years and years and years. And then you have the cost on top of that. Plus, it's a public record. So if anybody wants to snoop around and see what's going on in this conservatorship, they're going to see the assets. They're going to know every player. So the thing to do is to have a durable power of attorney, have it updated as things go along, so that you get to appoint the person that you want, instead of the judge who doesn't want to appoint anybody has to appoint somebody.
And we can avoid court.
Yes. So with the powers of attorney, the huge thing is, do we want to have all this publicity and court involvement? When you talk to people and I talk to people, we ask them, who wants to be in a court proceeding? Nobody raises their hand.
Including us.
Yes, exactly. I don't want to be there. No. Courtrooms are not exactly the Hilton, are they? So anyway, you want to stay out of court.
Correct.
This allows that to happen. So we keep things private, much more confidential, way more cost effective. It just takes somebody to be a little proactive to have a power of attorney.
You know, we don't like to talk about this, but the reality is it could happen to any of us.
Absolutely. And it could be a car crash.
It could be anything.
You simply don't know. You have examples, I have examples of, wow, how did that happen? But once it happens, tell people, you either have the document or you don't.
There's no middle ground.
Yes. When I sign with the clients, I say, we're going to kiss this document if we ever need it. Hopefully we don't. But if we do, hallelujah.
Exactly. So if we've convinced you to think about planning, how can they reach you, Bob?
They can reach us at familysecurity.lawgroup.com or 805-496-4681.
All right. Thank you for joining me.
Thank you. Thanks for having me.
And thanks for joining us for this episode of Conversations with My Real Friends. We'll see you on an episode soon.